Well, hello and happy Saturday, everyone. It's good to see you guys here. We are back on my favorite topic. It's something that's so many of our Roman empires. Vanzan, the scammiest sham of all. And it's this something that I talked about a lot last year. As soon as we found out that this is what happened and that this is how Blake and Ryan got all of that information that they got off of Jen Abel's phone. I imagine all of you know what I'm talking about, but if there's somebody new here, Vanzan is the name of an LLC that Blake and Ryan own. It's only ever been used, as far as anyone can find, it was only ever used to ship some furniture over from England for a video that Blake directed that was for Taylor Swift. So this is the LLC, and prior to this lawsuit that we're in now, Vanzan filed a lawsuit in the New York State Court, not federal court, claiming breach of contract. And it was that lawsuit that was used in order to get all of the information from Stephanie Jones, who had just confiscated Jen Abel's phone, and she handed all of the information from Jen Abel's phone over to Blake she did that immediately. On the very same day she took Jen Abel's phone, she got it data scraped and she shared it with Leslie Sloan. We know on that day, and we know that because Leslie Sloan called Melissa Nathan and said, "I've seen the texts and we're going to sue you." So after that information had already been shared, months later, they decided they wanted to put an article in the New York Times, and they had to legitimize the information that was illegally scraped from that phone and passed along. And so that's where Vanzan came from. We finally have that subpoena, and so because the subpoena is out, a lot of people have been talking about it again. And so I want to talk about it again too. But what's bothering me right now is that a lot of the Blake apologists are defending it again. Even some of the ones who call themselves attorneys, they're saying there's nothing wrong with this, that it's clever lawyering, and we've heard that before. But is it? Opinions don't matter. We all have opinions, but opinions are not facts, and they don't prove anything. So what I'm doing today is I have spent hours and hours and hours digging up cases in New York, because this, as I said, was in actual state court, not in federal court. And all of the videos that I did before, I focused on federal court. But this time, I went straight to the very same courthouse where Vanzan was filed. And I found a bunch of case law from that. Because in the end, that's all that matters. Not my opinion, not anybody else's opinion. It's about what do the rules say and what has case law said. Now, you guys know how I love procedure. If you've been following for a while, you know that I absolutely love all the little details of procedure, binding authority. That's what we're going to do today. And I've got to say, I feel a little breathlessly nervous because for the first time ever, I tagged a few attorneys. I've never done that before, and I'm feeling kind of cheesy about having done it. But the reason that I'm doing it, if any of them do happen to wander over here and take a little look, the reason I did that, it's not to promote myself to them, but because I did all this research, I have all of this case law that I'm going to show, and I want to offer it to any and all, except pro-Blake attorneys, to any and all attorneys who care to use it so that they don't have to do, I know they're very, very busy, and I know that they could take this information and explain it so much better than I can. So I just wanted to, since I did all the work, I just wanted to offer it to any of them. Come take it, take screenshots. If you want to message me, I'll send you my slides. but I just want this topic covered. So that's why I did it. But I wanted to mention specifically, there is one attorney, I'm not going to say her name, but I think you all know who she is. The most prominent of the Blake, the pro Blake Lively people. There's a lot of rumor that she might be being paid or been asked to do this directly by Blake. But if she is an attorney, then she absolutely knows that what she's saying is rubbish. If she doesn't know that, then she probably needs to go back to school. But there are different types of authorities that are used to make rulings on cases besides just the rules themselves. And that is, most importantly, what I mentioned earlier, is case law. So if this attorney or anyone else is trying to sell you how something should or should not be done, always ask for the case law to support what they're saying. If what they're saying is correct, they will be able to find it. Just like I found a mountain. I found more cases than I can even talk to you about. They should be able to find it. But there's no way on this green earth that they can cite case law, especially binding authority, that supports what Blake, via her law firm, Manat, Phelps, and Phillips, I'm talking about you, and Stephanie Jones, via her law firm, did with the Vanzan Sham scam. Absolutely no way. How can I say that so resolutely? Because I'm presenting to you today what binding authority says on this matter, and it is most certainly not okay. So guys, in the chat, I want to let you know, I mean, you're probably getting used to it by now. I normally would have done something like this pre-recorded, but it just takes so long to do that. And I wanted to get this out right away. I'm still backed up trying to catch up with the motion for summary judgment with all of the unsealed evidence we have now. So, but I'm going to ignore the chat just to keep my brain on track. And at the end, if you have any questions, please remember them, write them down, and share them with me at the end, because I won't be able to read all of the stuff I've got to share with you today and keep up with the chat. So my apologies again for that. But first of all, what is case law? If you've been following for a while, you already know that. But if not, what it is previous court decisions that applied the rules for whatever state or district or circuit that a court is in. The important word in case law is law, because these decisions become a law of their own to determine the outcome of future cases. So different court decisions have different strengths. What's that about? There are lower courts, intermediate courts, and high courts. Stare decisis in Latin means to stand by things decided. This requires courts to adhere to legal precedents that have been established by previous rulings when they're facing similar facts. It ensures consistency, stability, and predictability in the legal system by forcing courts to follow higher court rulings, both vertical and horizontal. And the binding is vertical. It goes from up to down. The persuasive goes across. This keeps the law fair, or as fair as it can be, as equal as possible. So when there's limited instructions in laws, rules, and codes, because they're not written in pages and pages and pages of detail, the laws are pretty basic. So we're not at a loss about what's right and what's wrong because we have case law. It becomes the standard and the binding authority in future decisions. So we've been focused on the federal side of things because we've been covering a federal lawsuit. But Vanzan, like I said earlier, was filed in a New York state court. So it comes under something entirely different. And now I've been using this same chart all along. To the left, we have the federal. This is the horizontal view of things. So in federal, we have the Supreme Court is the highest court. That means whenever they make a decision, it is the supreme binding authority. So whatever they decide, when any of the case or any of the courts beneath them have to make a decision that has anything to do with that decision that's been made, because of stare decisis, they must follow the Supreme Court's ruling. They have to rule the way that the U.S. Supreme Court ruled. Beneath that, we have the U.S. Court of Appeals. That is, the country's divided up into circuits, and whatever the U.S. Court of Appeals in your circuit has decided, then the lowest courts, the federal district courts, they are bound by that authority as well when they make their decisions. So the U.S. Court of Appeals has to follow the U.S. Supreme Court. The federal district courts have to follow both. So when judges are making decisions, they have to first check, has the U.S. Supreme Court ruled on this? If not, has the U.S. Court of Appeals ruled on this? If not, they can use other districts' decisions as what's called persuasive authority. But they do not have to follow persuasive authority. It's just their kind of, well, to persuade them, to help them make their decision. But that is how that works. So then we have the state, but New York, well, New York is kind of whack. They do things kind of their own way. No other state, I have to say, no other state is set up the same way that New York is. So normally in every state besides New York, the Supreme Court, the state Supreme Court is the highest court. But in New York, it is the lowest court. They call it a Supreme Court. Their judges are not called judges. Their judges are called justices, and they are appointed by the governor, and they're appointed on 14-year terms unless they turn 70 before their 14-year term is up, because 70 is the mandatory retirement age. Most states do have that, but then, so it's very confusing when you hear the Supreme Court. You feel like it's the high court, but it's not. It's the opposite. So above them is the appellate division. Now, most states have one appellate court. There are a few that have two, but it's usually one is civil court and one is criminal court. But in New York, it's divided into four, and we're going to look more closely at that in just a moment. And then above this appellate, they call themselves divisions. These appellate divisions are intermediate court. And then the highest court is called the New York Court of Appeals. And it has the same binding authority that the U.S. Supreme Court has in federal court. And then the appellate division courts have the same binding authority. But what's confusing there is in most states, those appellate courts, there's just one, and it rules the entire state. But because New York has four that are divided by circuits, they are only binding authority in their circuit. Well, let me go ahead. Yeah, this makes it look a little bit more clear. So let me see. So these are how it's divided. Sorry, gotta catch up with my notes. Like I said, there's 14. Now they're inside New York. It has 13 separate judicial districts. Those are for like the lower courts. But then when you come to the appellate courts, they've got the four. And if you look at that teeny tiny little green spot, it's the smallest of them all. but that is in New York County. This would be the one where Vanzan was filed. So this is going to be our main focus for today. But because this is the city, this is a huge population all packed in a teeny tiny space. That's why it is so, so very tiny. But like I said, this is where Vanzan Sham was filed. And so that will be our main focus area for today. Sorry, I'm catching up on my notes real quick. I have a lot typed here. Okay, I think I covered all of that. Okay. In New York State, the set of rules that they follow, we've been following the FRCP, and that's the federal rules, and those are applicable in every state, but only in federal courts. So if you're talking about the state courts, they all have their own distinct set of rules. So CPLR is the New York set of rules. And the CPLR stands for Civil Practice Law and Rules. So this is not criminal. This is specifically just for civil. Okay. So which rule covers Doe lawsuits in New York? It is CPLR section 1024, subheading unknown parties. So this is what the rule says, and we're going to pay attention to the words in here. And like I said, the rules are put there and they're really basic. They don't give you this long list of interpretation. So that's why case law becomes so very important, because this is all we have. This right here to explain Doe lawsuits. So what it says, a party who is ignorant in whole or in part of the name or identity of a person who may, this is important, properly be made a party, may proceed against such a person as an unknown party or a Doe, John Doe or Jane Doe, by designating so much of his name and identity as is known. If the name or remainder of the name becomes known, all subsequent proceedings shall be taken under the true name, and all prior proceedings shall be deemed amended accordingly. So this type of lawsuit, because that's all we got, we have to turn to case law. And in that case law, we're going to find many more rules and a lot of sticky red tape. Very, very important, because the law says so little, what it does say, we have to pay great attention to. So what are the important things here? Ignorant to the name. There's no way around this. This is the rule. This must be applied. A Doe lawsuit, first of all, has to be because you do not know the name of the person. So that is one of the requirements. You have to be ignorant of the name. Now, what do we know about Vanzan? She filed that lawsuit. What did she do? Now that we've seen the subpoena, it was directed straight to Stephanie Jones and Stephanie Jones' attorneys. What does that tell us? She was not ignorant to the name. There was no reason to file a Doe lawsuit because she knew exactly who she was directing this to and exactly what she wanted from her. So we already see some trouble with Vanzan. And these are the rules, mind you. This is not an opinion. Okay, what else? Who may properly be made a party? So if you filed a lawsuit, there is always an opposing party, the person that you're trying to sue. So the whole point is, this is the person you intend to sue, but for some reason or other, you don't know that person's name. In most cases, what a Doe lawsuit is for has to do with someone online. Someone online has done something. You may have an IP address. You may have a username, but you have very limited information. And you need to find out who that person is because you want to make them the opposing party, the defendant to your lawsuit. So that it stands to reason that they can be the proper party. That's important to remember. All right. Another thing, so much of his name and identity as is known. So whatever it is that you know about this person, you have to put that there. That includes if you have more than one doe. So for example, the Vanzan lawsuit was does 1 to 10. So we know that it was going to be more, or supposedly aimed at more than one person. So if, for example, you know one or two of the people involved, if you know that it's multiple people, you put the names of those that you do know. And then you go about your pre-discovery action, or your pre-action discovery, sorry, I said that wrong. And as you learn the names through that, you will then add their names to the lawsuit and continue with the lawsuit. But what do we know about Vanzan? We know that as soon as she got what she was looking for, she closed it and opened an entirely different lawsuit with entirely different causes of action in an entirely different court. So this was never what she intended to use it for. All right, and we're going to use these qualifications and the qualifications we're going to come across in case law to see how Vanzan sizes up accordingly. Are there any other rules that apply? This first case law we're going to look at, this actually is a current case. It is also in the same courthouse where Vanzan was filed. This is going to teach us a lot. Some of this stuff took place back in July over the summer when we were first finding out about Vanzan. So this is very, very current information, and watching how the very court where Vanzan was filed handled the Doe lawsuit is going to show us how Vanzan should have been handled. This is so very important. Okay, so the plaintiff in this case is a Mr. McDermott. I believe his first name is Michael. And he's bringing this action pro se, which means he's filing it without an attorney, but he's representing himself. He has had attorneys throughout the process, as we'll see, and he does seem to be very well versed in his submissions. But what he is seeking is called pre-action disclosure. It is a Doe lawsuit. That is exactly what a Doe lawsuit is. You need to find, before you can take your action, you need to find out the name of the person. So it is pre-action. You're not supposed to begin an action until you've done everything properly. Okay, so pursuant to CPLR, here's another rule. Now we're going to go through this one a lot. Section 3102. And I'm going to show that to you in full in just a moment. But pursuant to this rule, which is brought by way of what? Special proceeding. That's a hearing in the court and not motion. So because he's representing himself, he made a mistake here. He filed a motion, but it's supposed to be special proceeding. And the court says, because we understand he's representing himself, we overlook the defect, but we're going to help him out. We're going to show him how to do this. And that's what they do. So what he's looking for subpoenas, but he's directing those subpoenas to his own email, his own social media, his own digital account providers for his own records, because in those records, he will be able to identify the defendant. So what he's asking the court for is not really so invasive. It's not like the way Blake and Ryan, the kind of subpoenas they served on us that were so invasive. They were asking for our bank account information, our location information from everywhere we logged into YouTube, our subscriber information, our addresses, everything about us, so entirely invasive. But this guy's like, hey, subpoena my stuff so that I can find this out. Okay, this next part is extremely important because what does she say? She says that he has shown a meritorious claim and that the information he seeks is material and necessary to that claim. We're going to talk about this a lot. It says, and that the information he seeks, oh, I already read that. The standard for CPLR Section 3102 pre-action discovery is that there is a meritorious claim. And it cites some case law here. We are going to cover the matter of Uden versus New York City Transit Authority. Some of this I covered when I talked about my subpoena and when I've spoken about Vanzan before. And this is one of them because this is one of the main citings that's used for a Doe lawsuit. So what does it say? And this is taken from Belmont versus Bristol Myers Squibb. Like I said, there are tons and tons of case law about this. So it's inexcusable that an attorney thinks this is okay. Pre-action disclosure permitted where petitioner has shown existence of meritorious cause of action and that discovery is material and necessary to that cause of action. So she's saying these are the standards because even judges have to follow the standards. They have to follow this case law. But this one, do you see where it says first department? Remember I showed you that New York is divided into 4 departments? And this court is in that first department. So for her, this is her binding authority. So this is what she herself must apply when she's deciding something. Okay, but she's saying there has to be this hearing and he has to prove a meritorious cause of action. So what a meritorious cause of action is that your claim has merit, that it's legally sound, that you have a right to ask what you're asking for. So it mentioned this other rule, like I told you, CPLR Section 3102, specifically C, and this says before action commenced. So this is pre-action discovery, and this is how a Doe lawsuit is supposed to go. You are not supposed to just be able to jump in and start sending out subpoenas. You have to get this information first. Okay, so this is what this rule says. Again, it's not a long rule, just exhaustive, explaining any possible situation. It's a basic rule, so every word in here is a must. Before an action is commenced, disclosure to aid in bringing an action, for example, finding your defendant in the first place, to preserve information or to aid in arbitration may be obtained. So this preserve information, this is not something we're going to talk about today because this is not related to Doe lawsuits. This is, for example, say I'm bringing a case and I know that what happened to me at this store, I know that it's on video now, but by the time I can bring a case to court, it may be months to a year or more. That video might be long gone. I need to preserve it. So before my action is really underway, I can come to the court and say, look, I'm bringing this action. I need this video. Can you give me this subpoena or this order so that I can get and preserve this evidence? Or even like maybe not even get it personally, but have it, tell the people that have to preserve it. Something like that, okay? Maybe obtained. This is so, so important. But only by court order. I've made a mistake of looking at the chat. I want my 9 minutes. I think that's Diane. So it was not filed in the Southern District of New York. That's federal court. The circuits are, and that's Second Circuit. That's federal court. This was in actual state court. So that's what we're talking about today. So CPLR is New York State rules. And I think I saw Leanne. Is Leanne here? Hey, Leanne. If you want to join when I finish all this, just to like talk about it, you're more than welcome to. Just let me know if you want to, and I'll send you the link. But only by court orders. That's so important. Please, if you remember anything, remember that. The court may appoint a referee to what? To take testimony. So these two rules together, the one we read before, 1024, and this one, 3102, these are the two rules that are absolutely necessary when you're dealing with a Doe lawsuit. Now, can it be any more clear, this rule, looking at it? It needs a court order. Okay? It needs testimony. So everyone who keeps saying that it's just fine that you file a complaint and you can start issuing subpoenas. I've heard so many people say, oh, in New York, you can do that. In New York, you can do that. You can do that in New York after an action is commenced. After. Notice this is before an action has commenced, only by court order. So what is the commencement of an action? That is when both sides have met and conferred. There's been a complaint filed. It's been acknowledged by the other side. And then the process has begun. If you guys remember back to this case, so they had met and we were waiting. We're like, when is discovery going to start? When is discovery going to start? And they were messing around with this and messing around with that. And then finally, after several things were sorted out, they'd already had a hearing with the judge to sort out the attorney's eyes only designation. Then discovery began. Do you guys remember? Because we kept saying, has it started yet? Has it started yet? And that's when they could subpoena. Why is that? Because of something called due process. I made a video about this a long time ago, explaining why Doe lawsuits are so protected. And it is because of a constitutional right called due process. This right is so important, it's mentioned in multiple amendments to the Constitution. But what that means is you have the right to be represented. Everybody has that right. After an action has commenced, both sides are represented. Or if the other side has chosen to represent themselves, that's their option too, but they are now notified of everything. So that every single subpoena that gets issued, no matter who it's from or who it's to, all parties get a copy of it. That way, if somebody needs to be protected, they make sure that gets protected. If somebody needs to file a motion to quash, like we all filed motions to quash, they get that right. But when you're talking about a Doe lawsuit, you don't know who that person is. You're trying to find that person's identity. That person still has due process. They still have a right to be protected. Because they're not represented, that leaves the court to represent their best interest. And that's why the court is the one that decides whether or not this subpoena gets issued. And only by that court's order and after proving a meritorious case. And we're going to see what that looks like. What did it look like in the case of this case that I've been telling you about, Mr. McDermott? Look at this. What do you see here? How many filings? This is the first page. There are exhibits, there are affidavits, all kinds of things. Why are they here? They are here because he has to prove a meritorious claim. And so this is what we see. So after all of these filings and all of these exhibits and affidavits and letters and requests and motions, the court says right here, the court has received plaintiff's proposed order to show cause, seeking discovery. What does she do? Does she say, okay, here you go. Please appear in courtroom 623. She gives him the address. She gives him the date. She gives him the time. For what? To be heard on the proposed order to show cause. This right here is required for him to get his subpoena. In spite of everything he's filed here and shown to the court already, he still has to come before this judge to show cause, a prima facie showing. This is what he has to do. And you saw all of this. All of this. That's what he had to do to be seen by this judge, to prove his case, to get his subpoena. Now, what's this on the right? Some of you might recognize it already. This is the document list. If you see at the top of it, this is the document list for Vanzan. This guy has, that one's too small for me to read, 107. How many are here? 2. There's a summons and a complaint, and there's a notice of discontinuance. Where did she prove her case? Where did she prove her right to get this? Where is all the meritorious claim? Where are the affidavits? There's nothing but these 2. This is the whole of the lawsuit. Now remember, there's all of that binding authority and persuasive authority, and the setup of the courts, the way they're set up, is all about keeping the law equal, keeping it fair. Now tell me this, why would this same court require that much from this guy, and this is all Blake had to do? Is there anything fair about that, or just or equal? No. And there is something very, very important I want you to take note of. Do you see that big purple arrow pointing to the words pre-RJI? Sorry, my mouth is so dry today. That stands, RJI is request for judicial intervention. This is pre-RJI. And what is stamped pre-RJI? The notice of discontinuance. And look at the date. That was December 19th. The next day is when her CRD complaint was filed, and the day after that is when the New York Times article came out. I mean, could it look more contrived than that? So before she requested a judge, she closed this. Why would she do that? We saw that a judge has to hear it. A court has to order it. There has to be a hearing. It's in the rules, and it's in what we just saw, the way this case played out. Why would the same court do these 2 cases so differently? Hold on just a second, guys. The answer to why is they wouldn't. The reason this happened is because nobody knew this lawsuit existed. Not one judge. Nobody. You file it with the clerk. It's not their job to look at your case and see if there's anything wrong with it. They just file it. And then they wait for a judge to manage it. They didn't even ask for a judge. They filed this. They sent out a subpoena that was already prepared, and they did it. And when they got what they needed and made sure they didn't need it for anything else, They were all set to file it. The New York Times said, we're going to print it. Then they yanked it. And the interesting thing is, the date that this complaint was filed was September 27th. And we know from Leanne and her metadata expertise that within a few days of this, in October, she was already sharing that stuff with the New York Times. So everything about this is sketchy. Everything. Do not let anybody, even if they claim they're an attorney, say that this was just fine legally. Because we know there was no judge. No judge touched this case. No judge looked at this case. No judge knew this case existed. Okay, now, I don't know if you guys saw Attorney Ferozen on, I hope I said his name correctly, on his first name is Daniel. He was on Zach's live the other day. It was so informative. If you haven't seen that, it's really, really worth a watch. It's so super good. He is a California attorney and he knows his stuff. He knows the woman who worked really hard to get 47.1 passed. And so he had done a live before where he explained that in depth. And now he was talking about this sham lawsuit and said, just like Brian Friedman, that this was abuse of process. And he explained some of the remedies that, excuse me, that Wayfarer can do about this sham lawsuit. And he called it a sham as well. And some of them will absolutely destroy Blake's case. So I don't want to get into that on today's episode, but I do want to talk about that later because I am planning an episode where we talk about what Wayfarer can do from this point. Okay, this is because I wanted to get the best definition of meritorious claims. So I came straight to the American Bar Association. So this is they put out the ethics and all of that good stuff for attorneys to follow. Rule 3.1 is meritorious claims and contentions. And what does it say? A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so that is not frivolous, which includes a good faith argument. That is what a meritorious claim is. It has to be based in law, has to be based in fact, cannot be frivolous, and has to include a good faith argument. If you're coming in with these shammy, scammy, hidden lawsuits, there is nothing good faith about that. We're gonna inspect her subpoena and that complaint one more time. I know we've looked at them before, but we're going to go through all this case law and these rules we've already gone through and look at it in light of all of that to see, was it based in law? Was it based in fact? Was it frivolous? Was it good faith? Okay. If I were Samantha and Manette, I would be very, very concerned at this point in time for having done that. And my issue is, I've always said when I very first found out they did that, I'm like, there is no way, and in a case this big with this many people watching, that is the first time they've done this. Absolutely no way. I will never believe that is the very first time they've done something like this. And I really, really think it's not now. And I covered a couple of months ago, I covered a case in South Carolina involving Nancy Mace, where someone had done the same thing. I think this is something that's being done throughout the country on the sly by unscrupulous lawyers, and it really, really needs to stop because it has the potential to be so very dangerous, and specifically, I think, dangerous to women. Just like They were able to access the entire contents of Jennifer Abel's phone, her private conversations and videos with her fiance, her private conversations and videos about her health, things with her attorney, things with her mother. Imagine, like, I just cannot fathom the violation she must have felt and still to this day feels. Imagine everybody seeing the entire contents of your phone, every conversation you've ever had with anybody. It's sick. And that is terribly dangerous. Women are stalked by exes all the time, every day. If they can use something like this to access their ex's phones, they can find them. They can find all kinds of information about them, hunt them down. Stalkers can use it. And to be fair, women can use it against men too. If they're targeting them for some reason, it's not just to one side, but I feel like it has the potential to be very, very harmful to women more than anyone. So that makes me nervous. But that case that I covered, it happened in South Carolina, and he did the same thing. He got used a Doe lawsuit, used it to get depositions done before discovery, and they got caught, and they got sanctioned, tens of thousands of dollars for doing that. So anyone saying this is okay, it is not okay. And yes, it was a different state. However, things like this, these kinds of laws are pretty standard across the country. So her attorneys, I feel, are going to end up in some trouble for this in the long run. And Attorney Feruzin kept saying, they could bring a new lawsuit against them about this. Their lawsuit got thwarted in this court, and he even was like, because Zach asked him, should they amend this or find some way to do this? And he's like, I would do it in another court, which I thought was really interesting. But I've said the same thing, because a lot of us have been like, why haven't they done anything about Vanzan? But that's what's been in the back of my head. They don't want to do it in this man's court. And I don't blame them one tiny bit. But I don't think this is the end of Vanzan. I don't think they're going to let them get away with it. Even if it's just Jen Abel that comes after them because it was her information. But it could be Wayfarer too, because they were under contract with Stephanie Jones, specifically an NDA, when she just willingly handed that over without alerting them. And this puts Stephanie Jones's attorneys in hot water as well, because their names are on that subpoena. They knew that Stephanie had contract with Wayfarer, and they know the ins and outs of that contract, and they know what an NDA is, and they allowed that stuff to be handed over. So this has a potential to be pretty huge and to blow up several different law firms. Okay, so here we're going to look at the order that this judge granted to Michael McDermott that gave him the right to issue his Doe subpoenas. We're going to see the whole process, and it's going to help us to understand, without a doubt, armed with this case law, to see what a nonsense sham Vanzan was. So remember, with orders, the reason orders are usually so many pages long and so descriptive, and we read it and we're like, why is he telling us everything we already know about this case? Well, because they become case law. They become a matter of record. So in something that may be viewed later, especially an order that may be viewed later, he wants in this case, she, I'm so used to saying he because we've been talking about Lyman, but this judge is a female. She wants to make sure that she has fully explained why she came to the conclusion that she came to. And so that's what she's done. So she's telling the whole details of it all, so that if it ever gets questioned in the future, she's got it all recorded. It becomes history. Not only that, she's explaining to the public why she decided what she decided, because court's information is for the public, for us to look at. So, first, she lets us know that this guy is facing danger if his claims are correct, and so it needs to be acted on. She also goes next into describing his due diligence, that she's explaining because he did everything he was supposed to do in the way that he was supposed to do it. That's another reason she decided. So you have to do your due diligence. Did Blake, with her little 2 filings, would you call that due diligence? No. What else does she say this guy did? He hired a forensic expert to look into his accounts to prove the hacking. So this guy has been being like cyber stalked, and um people have broken into his accounts, he's saying, and he has IP addresses because he's hired this forensic expert. So he has very good reason to aim at this Doe person because he does have some digital information. He also hired attorneys. What else did he do? She talks about the oral arguments. So remember, she told him to show up into her courtroom at a certain date, certain time to prove his case. So she mentions that. Why is that mentioned here? Because it's part of issuing a subpoena in a Doe lawsuit. Okay, she shows what he wants. He wants a subpoena to get records from where third parties like Apple. Sorry, hold on one second. Sorry, had a cough. Okay, so third party places like Apple, WhatsApp, Google, Grindr, and Facebook. And what does he want from them? He wants to identify John Doe. She explains what happened at oral arguments, that in that hearing she discovered that he suspected the identity of John Doe, but he needed further investigation to clarify who it is, and his records should show who, when, and how his accounts were being accessed. Now, in addition to looking up the identity of this John Doe, he also asks for a temporary restraining order. He's seeking records from the New York Police Department. Not only the police department, but also this specific hospital, and it's related to a wellness check and a hospital evaluation that allegedly was caused by the stress attendant to this conduct. Now, in this case, and this is important because it shows that even though she does issue the order for this subpoena, it's not like, okay, you passed, you get everything you want. Even still, it's not that way. Sorry. So he doesn't get that granted, and we're going to see why. But again, we go to due process. And like I said, I talked about this in more detail in a previous video. I just basically mentioned it today, but everyone gets that. It's a constitutional right. That is why this process involves so much red tape, like I said. All right, sorry, I'm catching up with my notes real quick. This is all stuff I already said when I talked about due process. Sorry, guys. All right. So this is where we're going to start getting into some of this case law. This is still the judge's order. So she just handed us all of these cases, everything we need to know about why Vanzan was so wrong. So we see, if you recognize CPLR, Section 1024, we've seen that already. We're going to see that all night. So she says this rule entitled unknown parties allows a party who is ignorant in whole or in part of the name of the name or identity of a person who may properly be made a party to proceed against such person as an unknown party. Here's where we start to find, remember I said we have the rules that are just basic, and then we get the details in case law. Here's where we start to see that. Here's one of them. She adds, and this is taken from Orchard Park Central School versus Orchard Park Teachers Association. What do they add to it? By designating so much of his name and identity as is known. So that means if you know anything about the identity, it has to be added. To be effective, the summons and complaint containing a Doe pseudonym must describe the unknown defendant in such manner that the Jane Doe would understand that she is the intended defendant by reading the papers. That sounds a little unclear right now, but we're gonna get to why that matters as because we're gonna come across that a lot. So this is one of the requirements. So say you don't have any idea, you don't know even a part of the name or the identity of the John Doe. So what do you have to do? What is required? Now look, this is from the second department. So this has already gone to appellate court. This is a higher court, has already decided this, that the Doe would be able to understand that this is about them if they see the paper. Keep that in mind, because this is a requirement now, because it's binding authority. It's been decided in a higher court. And what else? It is fundamental that the defendant must be named or described in such form as will properly identify the defendant and give notice of opportunity to defend. And that's what it's about. It's about due process. So if that person sees their name in this law, or sees not their name because their name's not known yet, sees this description of themselves, they will know, oh, this is about me. I need to defend myself here. That's why due process. This is what Jen Abel didn't get, or Wayfarer, or anybody else whose information was in Jen Abel's phone. Excuse me. Okay, sorry. All right. I think Ezra's making me sick because she doesn't like that I'm talking about this. Okay. In addition, here's another case. Bumpus, and I like saying that for some reason. Bumpus versus New York City Transit Authority. This is one of the most cited cases when dealing with Doe lawsuits. This is also binding authority. This is from the second department. So it's persuasive authority in the first, but it's often cited all over the state in all of the departments. The plaintiff must show they made diligent efforts to ascertain defendant by name. So just in these couple of paragraphs, we now have new requirements beyond the rule that have been decided in higher courts. So they are now law. And that's why we call it case law, because after it's been decided and it is binding, it is law. So these have added to what we already know, that you have to describe the Jane or John Doe so that they could identify themselves and get an opportunity to defend. And you have to show that you made diligent efforts to learn who this Doe is before you came to the court and said, I'm filing a Doe lawsuit. That's part of what you have to show when you have your hearing before the court, that you did make diligent efforts. So Can we say Blake made a diligent effort to find out who the does were in her lawsuit? Absolutely not. She filed the thing, got a subpoena, went straight to Stephanie Jones, and that is the only thing she did. She already knew her defendant by name. So she's already broken these, and we're going to get to that coming up. Okay. This judge says Mr. McDermott has demonstrated entitlement to proceed in this action against defendant John Doe. So she laid out all of the ways that he did it, but she's not done because these things are not taken lightly. She's still going. Now she's going to explain how he did it. First, the complaint contains adequate allegations. 61 separate factual paragraphs with details of the alleged intrusions and interference and consequent damages, from which John Doe would understand they are the intended defendant. So in his complaint, okay, think about Blake's. She's like, oh, it's a breach of contract that, somebody hurt or has the potential to hurt me and my family and my businesses. Is that descriptive enough? In this case, 61 separate factual paragraphs, and it talks about what this person did, how they broke into his accounts, how they hacked, how they did this. The person who did that knows exactly who is being discussed in this complaint because it's full of all of these details. So this is a requirement. Did she meet it? We'll consider that in a moment. Okay, and that is binding authority from this department, from where Vanzan was filed. Henderson Jones versus City of New York City First Department. So we know this was in the appellate court in that department. Again, due process, giving intended defendants fair notice. Okay, that's just the first prong. Second, Mr. McDermott has shown diligent efforts to ascertain defendant by name. How did he do that? He hired a forensic expert who performed an investigation of his accounts and then hired attorneys to subpoena his account information to complete the forensic investigation and clarify defendant's identity. And that was all okayed through this court before. Like that's all in those earlier things. He now seeks discovery from his third-party social media and digital platforms to complete the forensic investigation. Plaintiff seeking to identify defendant prior to expiration of statute of limitations may pursue inter alia pre-action disclosure under CPLR 3102 and FOIL requests. Okay, so this is another thing that Blake would have had to have done. She would have had to have shown the court what her diligent efforts were to ascertain who these does 1 to 10 were in her case. Where were the affidavits? Where were the receipts of any forensics she hired? Where was any effort by her shown to the court to show that she deserved to get this subpoena issued to her by court order? Doesn't exist. She failed again. Okay, the judge still isn't finished. Here we go. Although he seeks pre-action disclosure pursuant to CPLR 3102, here it says it again, which is brought by way of special proceeding and not motion. So the hearing that they had, that Blake never had. This is the one we read earlier. Okay, so yeah, sorry, I accidentally put this in twice. Let me see what my notes were on it this time. Okay, I think I was pointing to the, yeah, I don't know why I put it in twice. Sorry, guys. Okay. Now, like I said, even though she does approve the subpoenas that he asked for. Like I said, it's not just carte blanche. You can go start sending out any subpoenas you want willy-nilly now. It's not like that. So remember, he also asked for that restraining order. She says, however, these things that he's trying to subpoena, they stem from a wellness check that was initiated by his friends. And therefore, they're related more to what? His alleged damages, and are not related to the identity of John Doe, which is a crucial threshold issue that must be resolved in order to avoid dismissal of the complaint. So she's saying, all you can get with this is the identity of John Doe. That's your threshold. You have to resolve that. So this other stuff is not, though. This stuff is about your alleged damages, so it doesn't qualify. Now think about Blake's complaint. It was only about damages. There was nothing in it whatsoever about trying to identify these does. So again, failed. And then it says, because he has a limited amount of time in order to identify these does. And so he needs that. There's an urgency to getting those taken care of. But the rest of this is about damages, and that's stuff that you do afterwards, once you have your defendant. And then it goes into inadequate description. This is so important, guys. Renders the action jurisdictionally defective. So if your claim before the court does not adequately describe the doe you're trying to identify, it is jurisdictionally defective. And we're going to find out in a moment what happens to claims that are jurisdictionally defective. So did Blake's adequately describe the does? Did it mention anything about trying to find out the identity of the does? It did not. It would have been jurisdictionally defective. And that is why she didn't want this before a judge's eyes. She would have been sent out of that courtroom. The court declines to sign the New York PD and Mount Sinai subpoenas without prejudice to renewal during pre-trial discovery proceedings after he identifies John Doe, amends his complaint, serves it upon that identified individual, and issue is joined. So that's when it will become like a regular suit. When you can issues joined, the complaint's amended with an actual named defendant, that defendant can be represented, then they can talk about her damage or his damages. So, how different is this from what Blake did with Vanzan? And then here is the order where she grants permission for the John Doe portion, but denies the temporary restraining order for the reasons that we just discussed. So if any Lauren came to hear about the pies. I baked cookies. I didn't bake a pie, but I did bake some chocolate chip cookies. Okay, so that is what a Doe lawsuit looks like in the same court where Vanzan was filed. That doesn't look anything like what Blake did. So any attorney, especially one who claims to be a New York attorney, if she thinks that this is the right way to do it, she needs to turn in her law license. So she either knows and she's lying to the public, or she doesn't know and she needs to go back to law school. Something to remember about a Doe lawsuit. And I can't remember if it's in one of the cases that I clipped for you today, or if, because I read so many, but I couldn't put them all in because it's just so many. But it's referred to as an unusual remedy. Now, unusual in a legal definition is not the same as unusual in, like, when we say, oh, that's unusual, that's strange. It doesn't mean strange. It has a specific legal definition. So, what is that definition? It refers to a court ordered relief that deviates from standard, common, or readily available legal solutions. So, this is not a common remedy. This is not a common legal solution. This is not standard. These remedies are generally discretionary. That means it's left up to the judge's discretion. They have to do a case by case evaluation. Also, granted in extraordinary circumstances. It's not something that's done every day. It's not something that's easy to get. It's something that only in some rare situations where it absolutely must, and at a judge's discretion after hearing your case, is decided, and often equitable in nature, such as specific performance injunctions or constructive trusts, when traditional remedies are inadequate. So keep that in mind. This is not something so common that I don't care if it's New York or any other state, and I'm so sick of hearing them say, oh, in New York, you can do that. No, you can't. It is an unusual remedy, and it has a lot of requirements. We're going to get into many more of those requirements now. Sorry if these colors freak you out. I know they're all bright and ridiculous. Let me clue you into what they are. The yellow is just my regular highlights, and then I read something and I'm like, oh, this is so important, and so I go to green to make it stand out more. And then the blue, the darker blue, is case law that we're going to consider, and the lighter blue I highlighted, I think, just in the first page or a couple pages, because that shows you if it's just persuasive authority. Like if it's just New York, that's just another New York State court. It's not persuasive. I mean, it's not binding. It is just persuasive. But when you get to first department, we learned now, you guys are going to be so smart when we're done with this. This is the intermediate appellate court. And so its decisions are binding upon the lower courts. So when they say something, that becomes law for the court that dealt with Vanzan. Okay, so that's why I highlighted it for you, to get you guys used to looking for those in the cases that I cite. Okay, so we're going to start with Rivera versus the City of New York, and this was in 2017. And it cites CPLR 1024. Again, I'm not going to read it again. I read it a million times today and yesterday when I was looking these up, but they all start by citing that rule because they have to explain their decisions, just like we saw the judge do in that case we just considered. So this is what they're doing. They're explaining their ruling. So significantly, the proponent of such an amendment must establish that the defendant who at the time an action was commenced could not be identified. Okay, Blake filed this to get something from Stephanie Jones. Can we say that Stephanie couldn't be identified? Was named or described in such form as would properly identify the defendant and give notice of opportunity to defend. Remember, we came across that. The doe has to be described in such a way that they would recognize that it was them. So had she done that, and this case said an employee of Jones Works, which you have to describe as much as you can. So she knew she was sending the subpoena to Jones Works. So let's say somehow in the world of make-believe, she didn't know that it was Jen Abel, and she just sent the subpoena to Jones Works. It would have said the subpoena is going to Jones Works to an employee who was discussing retaliation against Blake Lively with clients or with other people, with media. That would have been how she would describe this. But that's not what she said. She was talking about breach of contract and harm to her family. There was nothing descriptive in that would identify a person. I mean, Jennifer Abel could have read that herself and said, that's not me. I didn't have a contract with Vanzan. So she failed in that. Okay. Then we have Goldberg versus Boatmax. We're going to get into that one specifically in a moment because that is binding authority. But CPLR 1024 must also establish that diligent efforts to identify an unknown defendant were made prior to commencement of an action to no avail. So you tried your best to find who this person was. You were unable to do it. And now this is all you can do now. But you tried your best. Binding authority, First Department. All right. Notably, when plaintiff knows or reasonably should know a defendant's real name, a John Doe designation in the summons is tantamount to a jurisdictional defect, and motion to amend the pleadings will be denied. What does that mean? If you actually know the person's name, but you call them John Doe or Jane Doe, it's a jurisdictional defect. You're going to be denied. Blake knew exactly who she was going for. It would have been denied. Do you guys see this? No attorney in their right mind should be saying that Vanzan was okay, because it tells you right here, if you know the defendant's real name, it's a jurisdictional defect and it will be denied. And that's why she did it all underhanded, did not ask for a judge, did not have a hearing, did not try to show cause, because she would have failed. And we're going to consider ABCO in a moment. And that is Lennon, as in John Lennon. This involved the Beatles. And it's binding authority. Okay, and then the first cited case at the top is the City of Mount Vernon versus Best Development Company. I've got it here at the bottom. The important quote from that is, a summons and complaint must describe the unknown party in such a manner that the Doe defendant would understand that he or she is the intended defendant by a reading of the papers. So that gets repeated and repeated, but it's so important because it's one of the big ways that Vanzan lawsuit failed, why it's a sham. Okay, so I told you we were going to look at that Goldberg versus Boatmax. This is binding authority. You see that First Department. So this got appealed. The appellate court made a ruling. It is now law. What did they say? They said the summons and complaint served on one of the intended defendants did not satisfy CPLR 1024, since its allegations did not fairly apprise that individual that he was their target. And then it cites some case law. Leibowitz versus Fieldston. And we have that at the bottom. What does that say? That says, well, CPLR 1024, I'm not going to read that. That's the rule again. Like I said, I've read it a million times. It is jurisdictionally sufficient only if the actual defendants are adequately described and would have known from the description in the complaint that they were the intended defendants. Nothing in Blake's complaint would have clued Wayfarer, Jen Abel, any of them in that they were the intended defendants. They didn't have contracts with Vanzan. Okay, back up to the top, there is also a mention of Tucker. We'll get to that on the next page. But it also, Goldberg has another quote that basically says the same thing, but it explains in this case why that one failed, because there was a description in the summons and complaint that it said that the Doe that they were trying to find, that they were persons in possession of plaintiff's boat. But by the time the action commenced, the boat was no longer in their possession for nearly 2 years. So they're saying that's how picky it is. That's not a detailed enough description because it wasn't correct information. You're supposed to describe it so clearly that these people, if they saw it, would have no doubt that it was talking about them. Okay, so keep that in mind. All right, and then the other one that I said we get to on this page is Tucker. Doe was described in the complaint as a physician licensed by the state of New York with privileges at the defendant hospital and as a doctor who performed cholecystectomy surgery. I think that's gallstone removal on plaintiff's decedent. So this is how the doctor was described. So it was a physician licensed by the state of New York. That's not super descriptive. Privileges at the specific hospital. Okay, that gets a little more specific. Then the doctor who performed the surgery on a specific patient. Well, a doctor can easily see, okay, I did this surgery. That's me. So in this case, it was descriptive enough. This one passed. So it has to have enough of a description that should the defendant see the papers and read the papers, they go, oh, that's me. This doctor would have no doubt. Oh, that's me. I'm a New York doctor. I work at this hospital. That was my patient. Okay. So as you see from this judge's ruling, Dr. Loriot was adequately described and would have known from that description that he was the intended defendant. So was Jen Abel described as a person who works for Jones Works, who represents Wayfarer, whose phone had been confiscated when she was fired? She would have known that was her, wouldn't she? But it didn't say that. Okay, another case we have, City of New York versus Doe. This was just a couple years ago when all of this stuff was happening in 2023. So in this case, the court found that the use of John and Jane Doe rendered the 10-day notice to quit notice defective ab initio, which means like at why did I just forget real quick? There's a Latin term, like from the beginning, from the start. It was defective from the start and doomed effective service. So this is not a subpoena. This is a notice to quit. But as you see later, I think it's on this page. It says they are, same standard. The yellow line between the green. Same standard in using a pseudonym for pleadings applies to predicate notices. So we can include this in there because it falls under the same standard as Doe lawsuits. Okay, so again, it repeats. You have to be ignorant of the name or identity. That's a requirement. If the petitioner knows the party's name, okay, you cannot know the party's name, or fails to demonstrate that diligent efforts were made to learn the name, you have to show you tried it. If you don't know the name, the use of the pseudonym renders the petition fatally defective as to that party. So Blake's fails for both of those reasons. She knew the name she was after, and she did not make diligent efforts to learn the name if she knew it. She didn't show the court any kind of effort that she made, and she knew the name. So 2 ways of failing right there. Okay, and here's where it says, see, it says unusual authority. Remember, that doesn't mean strange. That means extraordinary circumstances. The regular remedies won't work. You have to do something big. Okay, so the unusual authority sanctions, so that tells us this is not just an everyday small thing, and it requires a judge to rule on it. Should not be availed in the absence of a genuine effort to learn the true name of the party. A reasonable effort to learn the real name must be made before resorting to such service. And that's what you have to show the court, that you did, that you tried everything and you just couldn't find out who it was. So say Stephanie Jones had told Blake, one of my employees was retaliating against you, but I can't tell you who. Okay, then maybe Blake could have filed this and said, I know there's an employee at this company, but I don't know who it is. And I tried and I tried. I asked, but nobody would tell me. Okay, then, but that's not what happened. Okay, and it must be proved to have been made if such service is challenged. So it has to stand up to the challenge. Then it says, although New York does not require petitioners to identify their respondents at any cost, it means you don't have to spend a fortune hiring this specialist and that specialist. The motion papers raise serious questions as to whether petitioner undertook any effort at all to ascertain the identity of those it sought to evict from the lot before resorting to pseudonymous how do you say that word? Notices, and New York courts have criticized a want of due care before proceeding anonymously. For how long? For nearly 2 centuries. And it quotes quite a few cases that have shown that, going all the way back to 1861. They're like, this has always been the way. You can't just come to the court and say, I need to find out who this is doing this to me. You have to do this to a reasonable degree. Like it says, not at any cost, but to a reasonable degree, enough to convince a judge that you have done everything that you could do. In this case, it was denied because they said at the very bottom, it is clear that the city could have and should have identified the occupiers with any modicum of effort. So they're like, you didn't try, you could have done this, but you just came here and did this. So no, you don't get it. Okay, now back to this Rivera. This is where we pay attention to the ABCO. This is the one with the Beatles. All right, and this 1976. So this is after they were broke up, and I didn't have time. I really wanted to look like, what is this all about? But I didn't have time to go into it. But you guys can look it up later if you're fans and want to know. An additional basis for dismissal. So this part of the lawsuit gets dismissed. This man, Borham. Why does he get dismissed? Because his name and identity had been known to plaintiff well before the lawsuit was instituted. Just like Blake knew the identity of Stephanie Jones and Jen Abel well before this lawsuit was instituted. CPLR 1024 allows use of the John Doe caption only where plaintiff is ignorant of the name or identity of a proper party defendant. So they're like, right off the bat, you guys knew who this was. So you fail. Additionally, oh wait, they repeat it again. This is like further down in the order, but they say it again, but he makes it more descriptive this time, saying again, it's a basis for dismissal, that this is allowed only where plaintiff is ignorant of the name or identity. Borham's name and identity had been known to the plaintiff well before the lawsuit was instituted. If plaintiff wished to add Borham as a party, plaintiff should have acted in accordance with CPLR 305, which is the regular process, not a Doe lawsuit. Plaintiff's failure to do so by itself requires dismissal of the action. So there were other reasons mentioned. Then he's like, those don't even matter because he didn't pass this. The most important test. You knew who this was. You cannot file a Doe lawsuit when you know who you're looking at. Dismissed. Okay. Then we have George Tutt. We got some fun names here today. Bumpus and Tutt. This one was in 2008. We see the quote from the rule again. You guys are going to know it by heart. And then it says the court must carefully search the record to see if, in fact, the petitioner had no knowledge of the respondent's name or was unable to obtain it. So the court, when you come before the court to prove your case, the court, what's their requirement? The judge has to carefully search the record to see if they did. That's why there's a hearing. That's how you make sure there was a meritorious claim. He has to carefully search the record. Was there a diligent effort to learn the party's name, a condition, precedent to the use of CPLR 1024? It's required, which should therefore be turned to only as a last resort. Let's see. Now, in this matter, the petitioner knew the name of the respondent. It's another one just like the Beatles one. Prior to the commencement of this proceeding, finding is fully supported by the evidence. So they're like, we looked in the evidence. We know you knew this person. Under the circumstances, landlord's use of a fictitious name in the pleading to describe respondent was not authorized under CPLR 1024. This is what a court would have found with Blake and her Vanzan. Identity, because what is a Doe lawsuit for supposed to be? Identity. You're trying to find, like it says, identity is sought to be amended from the fictitious nom de jour with a true name. That is the sole purpose of a Doe lawsuit, not to get the contents of somebody's phone, but there's somebody who did something to you that you want to sue, but you don't know who it is, and you're only supposed to use it to find that identity so you can put that person's name in there and proceed with the rest of your lawsuit. His statement that I was never provided proof of her name is belied by his own hand in his letter, which has proved to be the death knell to this application. For petitioner to now assert that it had no proof of the respondent's name is disingenuous at best. So they're saying this guy came here saying, I don't know who this person is, but look, in this letter, they say the name. In Blake's subpoena that follows this complaint goes straight to not only to Stephanie Jones, but she even knows Stephanie Jones' attorneys' names. Disingenuous at best. And by saying disingenuous at best, it's implying that there's a worse, that you did it to be conniving. Okay. Ulrich versus Rosas. This is 2019. The process requires petitioner to describe the Doe, and we already went through that rule, so that they would recognize themselves in the complaint. But in this case, petitioner knew that Gonzalez, who turns out to be the Doe he's supposedly trying to identify, and her two brothers have lived and occupied the property with Rosas for almost 10 years and has met directly with Gonzalez many times over the last 5 years. How are you bringing a Doe suit to someone that you've met with over years? This is just like, Lauren, this is just like what Blake did. The petitioner should have identified at least Gonzalez as the Jane Doe noted in the petition. Because the petitioner did not, the petition fails to comply with CPLR 1024. And they say this is particularly egregious. That's a big, strong word. When one considers that petitioner not only knew the names of at least 2 of the occupants, but the petitioner had also had a number of interactions over the years with those 2 occupants. Blake knew exactly who Stephanie was. Blake knew exactly who Jen Abel was. Blake knew who Melissa Nathan was. Blake knew who Justin and Jamie were. She knew all of these people. So, particularly egregious. If the plaintiff knows or reasonably should know the defendant's true name, an unknown party designation in the summons will generally be treated as a jurisdictional defect. Her attorneys knew that they were filing something that was jurisdictionally defective. They knew it, and they did it anyway. The petitioner landlord failed to exercise due diligence in ascertaining the proper name of occupants before using the procedure authorized by CPLR 1024. Judgment and warrant of eviction against John Doe vacated. The court just ruled in favor of the defendants, just like that. You did this wrong. You knew better. You did it anyway. You lose. You lose your case. In the words of Omar, how about that? That's what would have happened if she had taken it to court. Oh, I accidentally kept the same name on there. Sorry. In this one, she knew the name Labarge. You're supposed to say what you do know. If you don't know the whole name, it'll say what you know. They knew that there was the name Labarge. So sorry, I want to skip some of this because it's kind of long already. We're already an hour and a half. Could not have intended the complaint to designate them as defendants. Indeed, at that point, she already knew the name of Labarge and could have easily discovered Orlando's name. So you already got one name. How hard is it to find the other? Or at least put one of those names and not Doe. She did not make any further identification efforts with respect to these two defendants because she believed she did not have a cause of action against them. That could not have been within her contemplation when the John Doe complaint was filed. Accordingly, the use of CPLR 1024 was jurisdictionally defective as to these two defendants, and their motion to dismiss plaintiff's claims against them is granted. This is what happens when you file a defective lawsuit like this. You lose. You lose. That's why she kept it hidden. And now this is the one I mentioned earlier, Uden versus New York City Transit Authority. This is binding authority too. See First Department. It's binding in the very court of Vanzan. This one gets quoted a lot, even outside of its department. But pre-action discovery, which is what Doe is, may not be used to ascertain whether a prospective plaintiff has a cause of action worth pursuing. You cannot use it as a fishing expedition. A petition for pre-action discovery should only be granted when the petitioner demonstrates that he has a meritorious cause of action and that the information sought is material and necessary. And who do you prove a meritorious cause of action to? Who are you proving it to? It has to be a judge. There's no one else to prove it to. You can't just file a complaint and then go do a subpoena. You have to prove it. That entails a judge. And it says in the law, a proceeding, a special proceeding. Oh, thank you, Megan Ashley. She says, love you, Cassidy. Just stopping by to show support. Thank you so much. Thank you for the super chat. Okay, here, petitioner's notice of claim already set forth the time, place, and particulars of the accident. The only purpose of inspecting the file at this point would be to explore alternative theories of liability, which is not proper basis for invoking CPLR 3102C. So in this case, because I covered this case before when I was talking about Vanzan before, but this was an accident that happened in the subway system. And the petitioner wasn't sure how they were going to explain the accident. They were going to have to give a deposition to explain how they were injured. And so they were doing this little sneaky pre-action discovery because they wanted to see the video because they didn't remember what happened. They weren't sure how they got hurt. So they wanted to see the video before the deposition so they could use that information to get their deposition right, because without it, they were going to fail. It wasn't going to match the video. And the court's like, we see you. We see what you're trying to do here, and you don't get to do it. That's what judges rule when they can see you're trying to get funny with these kinds of lawsuits. These little shammy scammy stuff. We're almost finished going through this case law. I told you I got a ton of it, but I really, really wanted to make this point. Samad Bishop, this just outright says, pre-action discovery is not permissible as a fishing expedition. Could they be more clear? Only available where a petitioner demonstrates that he or she has a meritorious cause of action. The determination of whether a party has demonstrated merit lies in the sound discretion of the trial court. Who are you talking about when you say the court? You're talking about the judge in Vanzan, who was never asked to join the case. The judge was not in the room with us. The judge was somewhere with the SH claim. Okay, here is what we learned. Thank you, AC. AC says, "Oh my God, I just thought of the perfect audiobook for you to voice Little Women." Oh, I would love to do that. Is that one? If that one is has passed its copyright, then anybody can do it. I think it might. I've looked before at some of the older books that are no longer under copyright because I thought about doing some just on my channel that aren't under copyright. And that's something to consider. So remember we learned this Latin phrase, ab initio. This is from the onset, from the beginning. So as soon as it was filed. So a Doe lawsuit is defective. Let's see, did you guys learn all of these? Number 1, the plaintiff did not diligently attempt identification before filing. So remember, you have to, hey, Lauren, member for 9 months. Oh, you can have a baby now. Who is Vanzan? Do you mean Verizon? I thought this was a channel about pie. Lauren, you're welcome to join too when I'm almost finished. If you guys want to come up and have a little chat with the chat, we can do that. Just let me know. I'll send you a link. So that's the first rule. We saw this in case law today. Remember, case law, especially binding authority, is law. Has to be followed. Did Blake diligently attempt identification before she filed? 2, was the Doe defendant, did Blake describe the Doe defendant with specificity? Lauren's already in bed. 3, the listed Does cannot properly become parties to the action. Did she add them to the action? No, she closed it up and went away and did something else. 4, Doe is used, but it's defective when Doe is used as a shortcut to investigation or discovery. Cannot be used as a fishing expedition. This is your quiz, everybody. 5, was issued without, so it's defective when it was issued without proving a meritorious claim before a judge. Okay, Leanne. All right. How does Vanzan hold up to these criteria that we learned today? It doesn't. Let's look at it again. This is the subpoena. You guys have probably already seen it. This is one of the things that came in the mountain of recently unsealed information. We finally got to put our eyes on it after hearing about it for months and months. This is what it was. Look at the subpoena. This is supposed to be Doe. It goes directly to Stephanie and her attorneys. She knew exactly who she was headed for. What does it ask for? Material all documents and communications concerning Lively Reynolds, their families, and or Lively Reynolds companies. And what is it about? Inappropriate conduct relating to sexual harassment and retaliation. Related to the film. Now, I'm going to be flipping back and forth. We're going to look at, this is the complaint. The complaint, the nature of action is damage to plaintiff's business and plaintiff's reputation. All right. And what are the, on information and belief, defendants have certain contractual and confidentiality obligations and obligations of good faith and loyalty to plaintiff regarding plaintiff's business and reputation by way of oral promises and or written agreements. But the biggest fail with this is that this isn't Blake. This isn't Blakel. If she's going to say in the subpoena related to the film, that would fall under she herself personally or the LLC that she presented to do the film under. And we all know that was Blakel. It was not Vanzan. What contract did any of those people did? Nobody has a contract with Vanzan. Nobody. So who is this for? Not Jen Abel? Did Jen Abel have a contract with Vanzan? Did Wayfarer? No. So what in the world is she talking about? All right, excuse me. I'm gonna get this link to give real quick. Hold on. We can get Leanne up here now because I'm yeah, and you can join anytime, Leanne, because it's wrapping up now. But okay. Matters that impact plaintiff's business and reputation and disclosing to third parties and failing to keep strictly confidential plaintiff's confidential and or private information. All right, again, no contract with Vanzan. And what information was being disclosed about Vanzan, their business or reputation? Nobody knew Vanzan existed. How was their business or reputation being their confidentiality breached or their reputation being besmirched or their private information being put out? Nobody knew Vanzan existed. All right, I'm adding Leanne to the stage. Hey, Leanne. We don't hear you yet. I don't know if you're talking, but go ahead and start whenever you're ready.
Nope, sorry. I had to turn off my other screen then. I was talking over you.
Oh, okay. Hey, so I'm wrapping it up. So we're just talking about the actual subpoena and the complaint. Well, you were in the chat, so you know.
Yeah.
But yeah. So
yeah, that was very, very specific, wasn't it? The information they were asking for was incredibly specific for a Doe lawsuit.
Yeah, and didn't match, the subpoena doesn't match the complaint at all.
No. No, I mean, sexual harassment, you know, anything about sexual harassment, but the complaint said nothing about sexual harassment.
No, it just was like breach of contract.
Which in itself made no sense then for it to be a Doe lawsuit.
Mm-hmm.
Yeah. I think, I mean, I think Wayfarer, I don't know what Wayfarer's game is with it. I think they got something up their sleeve with Vanzan, but I think they're kind of parking it for the moment while they deal with the main case.
Yeah, I don't know if you had joined yet when I mentioned that, but did you watch Zach's with Attorney Feruzan? Did you watch his live?
I was like bobbing in and out, so for the most part I didn't see it, but
okay. Oh, it's so good. And
he watch her.
Yeah, you have to watch it. It's so good. But he was saying, and he kind of was like, I don't think I would add this to this court. I would do it
No.
in a separate court.
Yeah. 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 I can see the rationale behind that.
Mm-hmm. Yeah.
I mean, I am curious. Look, Friedman did say at the time this all come out that he would, explore every legal option available to them. So,
Mhm.
but it's been quiet, and like I think that's one of the top 5 questions I get asked is, well, what are they doing about Vanzan? And
Mhm.
we don't know. But I don't think they're not doing. I don't think they're doing nothing about it.
I
I think they're
agree.
just focusing on what's coming ahead of them first.
Yeah, I think so too. I think so too. And he also said this is abusive process,
Yeah.
and he called it a sham lawsuit. I mean, and that's just the thing. What do you think about this list of cases I found?
Yeah, that was it was really good. I enjoyed that. You
Yeah,
did well there, as usual.
thank you.
But
So
yeah,
I
I mean, altogether, they do make it very, very clear.
that it did not meet those standards.
No, it did not.
Yeah,
No.
Diane. He said they acted with unclean hands. Yeah, and
Yeah.
he also said, you know what I love that he said is that when it comes to Lemony, which we're almost there,
Yeah.
the judge already instructed them to get that stuff together. I don't know if you saw that in the order. He told them to get their jury instructions, and because I remember
Yeah.
when I saw that, I took note, like I want to do a video explaining what all that is, what that all means, because I've been talking about Lemony and explaining it a little bit as we've been going through since we are getting close. But anyway, he said in that they very well may end up saying all of this was ill-gotten and it can't be used.
I would
And that
hope that would be what I would hope they would do that.
yeah,
I
I
I
really hope
do.
they, and then what case do you have, like it's all gone?
Say again.
What
Oh,
case would they
yeah,
have
what
for that?
case
Yeah.
what case does Blake have? Yeah, no, exactly, because certainly the retaliation rested heavily on those text messages, but, you know, I mean, well, you know me, I don't think she has a case anyway. I
Me.
don't. The more you go into stuff, the less of a case I'm starting to see, and what I've started doing now is I'm now pulling apart the 17-point list as well,
Oh,
and,
good.
like, the subtle things like, she wanted Todd Black to oversee safety and everything, but, like, Todd Black's, PGA support letter for her says, "Well, I was brought on to help Blake with her creative vision." Doesn't mention anything about overseeing safety or anything like that at all, so,
Mm-hmm.
yeah, I just don't think there's any case, really.
No. And I don't know if you saw, I know we're all having trouble trying to keep up with each other's lives because we're so busy like getting through all of this unsealed stuff. So I
Yeah.
don't know if you saw my live the other night, and it was way too long. It was like 2.5 hours long. But I found where the female gaze came from. It wasn't
Oh, I
something.
haven't seen that one.
Yeah,
Where'd you
it
get it?
wasn't something. Yeah, it's a Cassidy After Dark because I really delved into the stuff from his notes. I looked up what it was, and none of that stuff came from him. And a big part of her claim came from his conversation with the intimacy coordinator. And there's a certain campaign called
Mm,
the CLIT test, and it's all about improving intimacy scenes in movies and TV, and whether or not they pass this standard, for do they properly show things from a woman's point of view and what a woman would like to see.
yeah,
They said, like, historically it's always been through a male lens, and they wanted to change it, so they devised this test, and they would literally go through movies and TV shows and rate them to see if they Lauren,
Yeah, that's what I was laughing at.
I've had a serious one up there I was going to talk about, but it's gone now. but but the female gaze is not something Justin made up, and it's not something that um that came from him. It came from this. It was directly said on that website. I found all of that. Because she's like, he came and he started talking about CLIT and describing, oral and things like this. And when you first read that, it's a little bit like, wow.
Yeah.
A lot of things, like when I read them the first time, I get a little nervous. Like, what is this? But I always know that Blake is not a trustworthy narrator. And so I always want to wait and see what the other side, how they describe it, what was actually said before I believe in it. And this is one of those cases. I was so happy to find out these were directly, remember his little handwritten notes from when he met with the intimacy coordinator?
Yeah.
It's all from that. I just
Yeah.
started Googling stuff in there and I found it
Well,
all.
I
I
remember,
need to take that section and make like a short video of that so more people can see it, because it's so long that not enough people are watching it. And I really want it to be known Justin didn't make this up.
yeah. No, absolutely. Um, that makes complete sense. I remember when the handwritten note sort of come out, and I can't remember who I spoke to. I can't remember if it was Mandy or Brett. It was someone with a background in that kind of industry. It might have been Dana. But I was like, what is this? Like, referring to the C test. I was like,
Mhm.
is that even a thing? Because I thought, honest to God, I thought, I don't know if it was like me being British, but I thought, is that just some American thing? Or is that a joke? Like, what is that? But no, it's genuinely a real thing that
Mhm.
they
They have a
have in that
website?
industry.
Yeah, they have a
It,
website, an Instagram account. I found all of it.
yeah, it's not like a big kind of, it's not like a weird thing. And someone with Blake Lively's experience, as she keeps pointing out, should know this.
Exactly. It's a movie thing, and it's a woman's movement. It's a woman's campaign, and she could have helped that campaign progress in the name of women. But she's like, oh, he's talking to me about the P word we're not supposed to say, corn. I was just so stupid to say corn, but I don't want to get YouTube angry with me. So yeah, that was her thing. So and I'm like, what? It's so funny because she's always been fine doing that kind of scene from a male
Mm.
lens, but when it's presented to her to do one from the female viewpoint, she's like, "Oh, that's dirty. Oh, you're harassing me. I'm gonna sue you." It's crazy. It's like, what is wrong with you, Blake? You're
Yeah.
supposed you claim you're a voice for women. You could have helped out a women's campaign. You could have made a difference. You could have been part of making a difference. But instead, you recoiled and sued the man and claimed that he did this. They also said in there that there were no upcoming scenes, intimate scenes gonna be filmed. But that
Mm.
is Lauren. Lauren, you should have just joined us. No, Lauren's gonna sue me. Oh, dang it.
Have
But,
you noticed, there's like an awful lot of moments where she has used the female card, and even the PGA letter, is, I've done all this, and women keep getting overlooked, and you should give me this mark in the name of all the women who have
but
who have been overlooked. And like, it's like, no,
yeah,
sweetheart, you're not asking for it for all the women. You're asking
you're
for it for
asking for your
yourself.
exactly. That's the only woman she speaks for is herself. Absolutely herself. And, oh, yeah, so the filming of the intimate scenes, do you the only reason. Because she's like, well, I didn't refuse to meet with the intimacy coordinator. We just didn't have, there was no reason to. We didn't have any scenes like that coming up. The very first scenes that were going to be filmed were supposed to be those scenes in Vegas, their wedding and their honeymoon. And
Yeah.
she's like, "Oh, can we put those at the end? I want to lose some more baby weight." And then he wasn't able to, so she just called in sick.
Yeah, she did.
And so that's the only reason nothing was filmed, but that was supposed to be the very first stuff filmed. So she's lying on her complaint, surprise, surprise, again by saying, "Oh, I didn't need to meet with the intimacy coordinator because we didn't have any intimate scenes coming up." Because everybody's criticized her because he met with the coordinator. He invited her to meet with the coordinator and she
Mm.
refused to meet with it. And now she looks stupid because we all know that. And she's like, "Well, there was no reason to meet yet." Yeah, there was, but you
Yeah,
called
there
off.
was.
So
I
she
you
could
know
have had, sorry.
no, sorry, no, go on, you go on.
She could have had that conversation with the intimacy coordinator instead of Justin, but she's the one that refused to meet with her. And then she's like, "Come over to my house and we'll talk about it there." So he brings his notes and she's like, "Oh, that's filthy. I'm not doing that." I mean, it's so crazy. And then she sued him. And the way it's put in her complaint, that whole part of the complaint, that's one thing I've been waiting for, the actual evidence, what happened here, because that's one of the things that looks bad in her complaint by her description of it. But now we have the actual what happened, and it's
Yeah.
not that at all. It's all lies.
Well, yeah, and, like, for me, because one of the biggest, I think the worst sounding out of all her complaints has always been the birth scene, and I've always been like, "Well, look, if when Wayfarer said, 'Oh, we've got behind the scenes footage,' I was like, 'Great, okay.'" But when you track the progression of her complaint and it's changed, it keeps changing.
Mhm.
Like, right
Let me
down to the thin bit of fabric, it used to
see.
be nude in all her
Nude,
complaints.
and
Now
now
it's
it's
black
black.
because the
The
behind the scenes
video.
footage is out and it shows it's black.
Yep.
And I had a whole thing when I was going through when I was going through that on my video. I had quite a few people, and I was like, I made a comment. I was like, "Well, logic would dictate that if it was the fabric was intended to portray her as nude whilst protecting her modesty, then it would be nude colored, to
Mhm.
her skin tone. Black would make no sense." And then I was like, unless she's trying to, portray that she's got some great big 70s porn star bush, something like that. But do you know how many people I had in the comments going, "Leanne, no, black still wouldn't make sense. She's a redhead. The carpets wouldn't match the drapes."
Yeah, it
And it's
just
like,
and
I love the way the community is like, "Oh, yeah," points out all these things. Did do you have any understanding? This is the see, I don't know whether I haven't, because I haven't been through all the unsealed stuff. So, I don't know if I've missed this or if it's not been kind of explained yet, but why was a second intimacy coordinator brought on? Has that come about yet? Because they had one. So what was the need for, I know it was in the 17-point list,
um,
but
was the second one brought on? I can't remember
yeah.
now.
'Cause she
Yeah,
said it
so
she says in her PGA letter as well, "I brought on another intimacy coordinator during the second half of production."
maybe just so she could say that, because
Yeah, I think so.
there was no reason to bring one on. I mean, she didn't
No.
even make the first one available to herself, and she never
No.
used the body double. If
No, she
you were
didn't. I that would have been a
truly
trap, mind.
Yeah, if you were truly feeling harassed by this man and you had to film intimate scenes with him and you had the option to let somebody else's body do that, wouldn't you? Wouldn't you? And he
Yeah.
had a body double too. And so she could have said, "Well, if you're going to show me, make it with his body double. And if you're going to put the camera on him, use my body double. And then I don't have to go anywhere near this man." If
I
you were
think that
truly,
he used the body double though, didn't he? Except for the close-up face shots, because he wasn't comfortable. Not
yeah,
that I can blame him.
yeah, he did everything he could to protect himself once he found out she was crazy. But allegedly, don't subpoena me again, Blake Lively. But or you either, Ryan, who's always fighting for your wife, like she, isn't strong enough on her own.
Yeah. Like, that was wild, seeing what the kind of things he was saying as well.
Yeah.
That's just crazy. That's
Yeah.
absolutely crazy. It's been definitely this unsealing is kind of, I think it's opened up a lot, and I mean, I don't, a lot, everyone, well, everyone I've spoken to who went to the hearing was really positive about Lyman and his thought process and the questions he was asking, and the fact that he was actually pushing back quite a lot on Blake's side as well. And I wonder if that's because now he's actually seen all the evidence, like, you know,
Yeah.
it's obvious even to a stupid person that there
Yeah.
was no sexual harassment.
Yeah, maybe because he's working on the summary judgment now. So I
Yeah,
mean, this stuff was, even though it was getting turned in, I'm sure he didn't have time to just sit there at the end of the day and peruse through it. But once it became the MSJ, he has to. So he's probably
yeah,
going through all that. And yeah, I wonder if that changed him up. I also feel like this time he wasn't on Zoom, and there were content creators there that were subpoenaed from his court, and there
yeah,
was media there, so I feel like it was probably a best behavior situation, but I think it could also be that.
yeah.
I'm hopeful, but I'm not you know counting on it being going like super good, but I'm hopeful that something will go well. It's gonna get us painful.
I think it's oh well, I don't know. What do you think is gonna do you think what do you think is gonna be dismissed, if anything?
uh
I sound like Elaine now, don't I?
the I th- I feel like I well Omar feels like the um the harassment will wait, what did he say now? Now I'm gonna get it confused.
He said anything to do with the sort of sexual harassment he thinks is gonna go.
Gonna go, and then the
Yeah, I'm pretty sure that's what he said.
yeah, I feel like that too, just because I feel like
Mm.
I hope so. I mean, I'm trying to think of what things would be um that would need a jury to decide. Like, I don't know. I guess there is some he said, she said. Yeah.
Yeah, on the specifics, but I mean, I think maybe, well, like the birth scene and the trailer issue. I think things that
Yeah.
involve the use of the word sexy,
Yeah.
because oh, I heard I can't remember who it was. Someone said that Lyman basically got Ezra Hudson to admit that use of the word sexy, is that Blake wasn't really offended by it. Um, so that wouldn't meet the legal standard for a sexual harassment.
Yeah. See, some of this stuff has to meet the legal standard, and it just
Yeah.
doesn't.
Well, I mean, it's got to be on a gendered situation. So, you know, it's got to be just towards women. And there are things like the hugging circles and things like that. And, where he's like, I think Justin referred to one of one of the possible atlases. And we don't know if it's Sklenar or not. But one of the potential atlases he referred to as pretty. So, it's not really gender specific then it's got to be severe or pervasive, um and there's
Mhm.
plenty that doesn't really hit that, but even if she hits that, then it's got to be like offensive to her, upsetting, that kind of thing. And I think there's even if you get past the first two hurdles, I can't see any of the instances of sexual harassment she's reported
Mm-mm.
getting past that.
Yeah.
And I can't see him relying on, the other people's either, like what Jenny Slate says or what Isabella Farah says. I mean, it's hearsay. Well, they've not brought claims. It could go to a pattern of work environment. But again, if it's something like the comment to Isabella Farah after the scene that she performed, he said, "Oh, that's hot." Well, he was also saying it to the male actor as well. I can't remember his name, but the
Mhm.
young Atlas.
Yeah.
So it's not gendered. And then you got the spoon thing, right? the actual spoon, that was
Isn't that in the book?
scripted. It was the look. It was like, oh, look in his eyes. Well, that's not sexual harassment. Jesus. If that counts as sexual harassment in the film industry, then directors are screwed going forward.
Right.
And then I think the other third thing she complained about was he apparently had a conversation with young Atlas months before that she was not party to, so it's totally hearsay. And suggested, said something about getting to know her and then winking. I mean, Jesus Christ, that's not going to meet any standard.
No, and then they end up together, so she should be.
They're exactly. Like you should be thanking him.
Yeah, and then so one of the scenes that I was concerned about, like how it was going to play out, and thinking that a jury might have to hear it, was the Jamie Heath and the makeup trailer thing.
Yeah.
But did you go through? So there's 4 depositions about that. There's Jamie's, there's Blake's, and then there's the 2 hair and makeup ladies.
And Alex Sachs.
What's that?
And Alex Sachs. Because she was with them with Jamie Heath, but went up to the door, up to the point he went in. So she heard him being invited in.
Oh, I missed that.
And she actually backed up Jamie Heath's version.
Did she?
Yeah, she did say that he was invited in, because Blake said she let him in, but told him to turn around, which that's fine. But the hairdresser and the makeup artist, they both seemed to say that they were like, "Oh no, we said no, no, no," but that's not what Blake Lively says. That's not what Blake said. No, there's like 3 different versions of that. Happened there.
And one of them had Blake standing up. One of them had her sitting down breastfeeding. One of them says she put a towel over the other exposed breast. The other one said she used the cutting cape to cover her with. But then Blake says she was sitting there still basically nude. So what were you standing? Were you sitting? Were you nursing your baby? Where was the nanny?
Were you not?
Were you covered with a towel? Were you covered with the cape, or were you just sitting there?
And we kind of pointed this out the other night as well. Like, there's one version where someone says that there's one version Blake says where she says, I think in her complaint, that he was staring at her directly, because that's where the whole I like to make eye contact thing is. But then in a deposition, she says that he was looking at her through a mirror. So it's like, what?
And what she initially accused him of at the time was eye contact.
Exactly, and I think if Friedman is up doing the cross-examine at trial, he's going to take him apart in seconds.
Yeah.
Because the other thing I noticed as well is in Justin Baldoni's deposition, right? Firstly, Gottlieb sexually harassed him. I'll just point that out.
Yes.
Because he pointed to a photo of Justin Baldoni. He said, "You're wearing a good-looking suit there. Or good looking at your outfit, or something like that. Your outfit looks good," which is literally word for word one of Blake's complaints. But they asked so little about the birth scene. It bothered me. And literally, the only questions they asked were, "Did you ask her to do it naked? No. Did you tell her that your wife ripped her clothes off? No." It's like, there's nothing else to ask. You're not going to ask anything else at all. Where was the intimacy coordinator? Why wasn't the set closed? Why was it chaotic? Why were people allowed their phones? Why didn't you get a blanket for her when she asked for one? None of those questions were asked.
Nope.
Tell me about this fabric she used.
Yeah.
And I think, well, they can't ask the questions because they must know that it doesn't hold water.
Yeah. Do you think they know she doesn't have a case?
Yeah, I think they do. By now, they should do.
Yeah.
I don't think they care though, and I think I got a sense of this. When we were dealing with them over the subpoena, actually, as like everything they do. So everything and like lawyers do that is billable. Every email has got a price on it.
And they
even if it's just like one line or to send you a
yep.
Zoom invite or something like that. Everything is absolutely billable. 4 different people sent me an email saying, "Oh, by the way, please don't record." They're just, these 2 are just cash cows.
Yep.
They are. They're because they don't care. They're gonna get paid.
Mhm.
And they're going through all this evidence. They've got all those amicus briefs as well, like which have done absolutely nothing. And I don't
Nothing.
think
He said he
I
didn't
don't think
even
they
read
will do anything at all.
No.
But they've had to, pay for all of that because people would have been paid for their time. All these experts, and it's just it's insane.
Yeah, I don't even wanna think about how many millions. I'm sure they're well over 10 million by now.
Oh yeah, definitely. I think on both sides.
Yeah.
And you look at like the court hearing from what yeah, it was Little Girl Tanya I was listening to actually. It's like
Oh, about
and
how
I'm
many
not actually old
were
and they
there?
were saying like there's about at least 10 lawyers for each side.
Wow.
Well, they're all being paid.
Yep.
So
Even the
that
person
just that hearing
speaking.
alone was an expensive day. Plus they had a second hearing in the afternoon for the settlement.
Mhm.
So yeah, all those people were being paid, and people like who come from the Los Angeles offices, like Friedman, and Ezra Hudson, they would have had all their expenses, their travel fare, any accommodation costs, and all that.
Mhm.
The parties are paying for all of this.
Yep. Yep.
It's
And
absolutely
well,
wild. So
Ezra's
yeah,
from
I can, and I mean, I think Wayfarer's bill is going to be much higher because Wayfarer have got all those dependents which are still in the lawsuit. They're also paying. So Steve Sarowitz is paying for all of the remaining Wayfarer dependents. Jed Wallace and Streets fees,
Mhm.
Isabella Ferrers, Jenny Slate. All the various people who've had depositions and then they've had legal counsel represent them.
Mhm.
They paid for all of that.
Blake should have had to pay for Isabella and Jenny.
No, I think so. Yeah, especially Isabella, given that she was swerving subpoenas for Wayfarer and just not cooperating.
Mhm.
But still got her lawyers' fees paid. It's
Mhm.
just
By Wayfarer.
shocking because the indemnity clause would not have extended to complying with a subpoena, or even or even trying to get it quashed. If she tried that,
Yeah.
the indemnity that Wayfarer would have provided to her as in her role as an actress would not have covered that kind of thing. That's meant for her being sued
Mhm.
for something as part of the film in
It's
a
being
role
exposed.
as an actress. And she wasn't being sued. She's just been subpoenaed.
Right. Yeah. It's ridiculous.
You
All
see,
right.
and
Well, I
as
just
one thing that we all proved is you don't need to pay a fortune in legal fees to,
no.
defend yourself from a subpoena and be successful as well, by the way.
Right.
We did it.
We did. We did. We beat those $1 million attorneys.
Yeah, we did. Absolutely.
From a top firm in the United States, New York and California. We beat them. That's pretty awesome.
Absolutely.
Yep.
I mean, that was stupidity, though, to be fair on her part. She kind of invited us to just,
She did.
write in with 30 pages of reasons of why we don't like Blake Lively. I got a lot off my chest.
Yep. Yeah, we got to speak our mind, didn't we? And get it on the docket. And
Yeah.
thanks to her. Yep. All right. Well, I just see the time. I'm coming up to 2.5 hours. Nobody's gonna watch my video again when they get this long. But thanks for joining, Leanne.
Oh, thank you for inviting me.
Yeah.
It's been a while, so it's been really nice to catch up again.
Yeah, I've been covering we've all been but I was going through the unsealed documents just to make some kind of organized way about it. I was going through the motion for summary judgment and then like pulling up the exhibits as they come up in that so that it tells the story
Yeah.
and it would be like how the judge goes through when he rules on it. But it comes out, it's a lot of work and it's so much information, and I'm racing to try to get through it before he makes his ruling on it, because once he
Yeah.
makes the ruling, it's kind of moot after that.
Well,
So just me myself, they're already outrageously long. So I'm like, if I get somebody else and we start chatting, it's going to be 5 hours.
oh no, I get it, because I'm very much the same. I'm still powering through. And we're having kind of staggered drops with, and don't forget, this is just the Blake Lively and Wayfarer case. The Stephanie Jones case haven't dropped
Yeah.
their unsealed documents yet.
I hope they wait.
Well, they are going to, I think, because as Lyman said they could, because there was, there was obviously more of a rush with the main case because of the hearing.
Yeah.
But there will be, I'm sure he will instruct a deadline for for everything in the Jones and Abel lawsuit to be,
He needs to
because
give
that's all
himself
got to be
some time
unsealed
too.
still as well.
Yeah. Yeah.
We
He
might
needs.
see more about Vanzan in that one.
Oh,
A lot of people
definitely.
are saying, "Oh, we're not seeing anything much about Vanzan other
Yeah.
than the subpoena," but
We'll
we
get
might
to.
actually see depot transcripts in there.
Oh, absolutely. I think because this is Jen Abel going after Stephanie. It's not just a
Yeah.
defensive thing. Like, she still has her claims.
Yeah, absolutely, she does. And I'm waiting to see if Stephanie Jones's her proposed amended complaint gets accepted as well, because some of that stuff was just wild as well.
Mm-hmm. Yeah.
Okay, well,
All right. Well,
I will catch up with you again soon.
yeah, thank you. Thanks for
No,
joining.
thank you. I'll drop you a message on X.
Okay.
All right.
All right. All right. Thanks, Leanne.
All right. Take care, everyone. Thank
Okay.
you.
All right. All right. And chat, thank you guys too. Thanks, Megan Ashley and AC and Lauren and Lauren again. Oh, I starred that to put it up. That's right. It was one I was going to come back to. You can't have pie. It's 10:20. I haven't had dinner yet. I'm gonna have that and start a pie riot. All right, guys, have a wonderful rest of your weekend. I probably will not be on tomorrow. I'm gonna visit family tomorrow, so I will see you sometime next week. Hopefully, continuing with the motion for summary judgment, if I can get through that. But I had to do this because I was sick of the pro Blakes saying Vanzan was fine. It was not fine. And now you guys all know, and you know why, you know all the ins and outs of how a Doe lawsuit is supposed to go. Feel free to take any screenshots of any of the cases I put up that you want to use for any kind of defending it. Have at it. I'm all about getting the word on Vanzan out to stop the misinformation out there that it was just fine, because it was not. Thank you, mods again. I know Christina's here. I think it's probably just Christina. But thank you guys all so very much, and happy weekend.